Good afternoon, everyone. Welcome to today's Dallas Volunteer Attorney Program Small Estate Affidavit CLE. My name is Catherine Saldana. I'm a mentor attorney with the Dallas Volunteer Attorney Program. Our program is a joint effort with the Legal Aid of Northwest Texas and the Dallas Bar Association. We serve those who live in poverty in Dallas County, and we partner pro bono attorneys with our indigent clients needing legal assistance. The Texas Small Estate Affidavit is a useful tool to settle estates in Texas. However, its use is often misunderstood, and the affidavits are frequently rejected by the courts because they fail to comply with the statutory requirements of the code. We are truly fortunate to have the Honorable Lincoln J. Monroe, Associate Judge of Probate Court Number 2 of Dallas County, speak to us today about how to submit a small estate affidavit correctly and when it's appropriate. He is both a certified public accountant and an attorney. Please join me in welcoming Judge Monroe. Thank you.
Good afternoon. I hope everybody is enjoying this very hot Texas weather. I'm going to start off with talking about Chapter 205. It's the smallest chapter in the Texas Estates Code, but it is an extremely broad-based chapter. And I want to talk a little bit about probate as a general concept. Whenever your best friend calls you up in the middle of the night and says, my mom just died and I have her will and she names me as the executor. Can you help me out? Well, most people say yes. And that type of a probate is fairly simple. You file an application, you file the original will, and if it's a self-proved will, you have an executor, and the executor, you have a hearing. You have to ask about 8 or 9 questions, and the person gets named as the independent executor, and you have to file an inventory, and you have to give notice to creditors, and you have to give notice to the distributees of the will. It's fairly straightforward. Well, 205 is a way when there is no will, and first and foremost, if there is a will, 205 bars bringing a small estate affidavit to clear an estate. Even if the family all agree they don't want the will probated, 205 bars it. 205 encompasses such a broad range of all the other sections that you have to look at Chapter 201 because the small estate affidavit has to indicate who all of the heirs are. And 201 has got several sections to identify the heirs who are entitled to receive separate property, the heirs who are entitled to receive community property, and what their shares are. And on our small estate recommended form, we have a section on that so that you can go to 201 to list out all of the heirs. 205 has all of your jurisdictional and venue items that are part of a normal application for probate. Where did the person die? When did they die? The 4-year bar that's part of Chapter 301 is not present on a small estate affidavit. So we get small estate affidavits frequently that are person's died 10 years ago, 20 years ago. I've seen one where the person died 30 years ago and they just found out they had property at the state of Texas. As we're going down what the form, and Maricela, if you could put that form on the page, if you could put that page up, put up the small estate affidavit.
Yes, one moment.
Okay. The form that Ms. Martin is going to show you on your screen is a form that's recommended by the probate court of Dallas County.
You should be able to see this form now.
I see an accreditation notice.
Oh, I'm so sorry about that one. Here it is.
Okay.
Here you go, sir. All right. Should be the form now. Let me know if you can see it.
Okay, I'm still not seeing anything except for the accreditation notice.
Here.
And while Ms. Martin is bringing that form up, The form is a recommended form. It's not required. It's not statutorily required, but it is a form that Dallas County has on its website, a PDF of the form. And if you need a Word version of the form, if you'll send an email to the staff attorney for Probate Court 2, Charlotte Key, and her email address is Charlotte, CHARLOTTE .key, K-E-Y, at dallascounty.org. She will email you or reply back with a Word version of this form. And as you look down the form, excuse me, it's going to require the decedent's name, the day that they died, and the year. Now, the form says Dallas County. The person may not have died in Dallas County, and you would edit that out and put in the county that they died in. It's followed by in bold, letter B, a copy of the death certificate. We have to have a copy of the death certificate before we will, okay, I'll repeat the email address. Charlotte, CHARLOTTE .key, at dallascounty.org. She is the staff attorney for Probate Court 2. You have to include a death certificate, and I'm going to suggest that whenever you file the death certificate, that the Social Security card number is edited out or blanked out. And what we look at on the death certificate, first off, is this the right person? And secondly, who is filing that death certificate? Sometimes that's also an error. The next line, the more than 30 days have elapsed, that's a requirement under Chapter 205. The next is a jurisdictional venue line. The decedent was a resident of and domiciled in whatever county they're domiciled in, state of Texas. I'm going to point out to you that if the person died in Waco and they lived in Waco, you're going to have a hard time getting the court to approve the small state affidavit because we really don't have jurisdictional venue. The one exception is next of kin, nearest kin under Chapter 33 of the Texas Estates Code. But we really don't like doing that. That's an item that should be filed in the county or where the person died or in the county where they resided. Letter E is critical. Decedent died without a will, intestate. If there is a will, 205 bars presentation of a small state affidavit to collect the estate, even if there's a family settlement agreement. Reptil has mentioned a couple of times that they may be trying to have that section amended to allow a small state affidavit if there's a family settlement agreement. But as of yet, no. It's also required that no administration be pending. Frequently, an attorney will file for a determination of heirship, and then when looking at the assets, figure out that they really don't need to do a determination of heirship. But if it's pending, we cannot grant the small state affidavit. We cannot approve it. So you'll have to dismiss those pleadings. The next part, letter G, if you could scroll just a little bit. This is a real critical line, and people don't understand how critical it is. The value of the estate assets on the date of the affidavit, not the date of death. Somebody died 20 years ago, whatever they had on the day they died, that value is not relevant. It's the date of the affidavit, excluding, this is critical, excluding homestead and exempt property. I'm going to talk about homestead and exempt property in a couple of minutes. The value does not exceed $75,000. And then letter H, which is a companion to letter G, the value on the date of the affidavit of the estate assets, excluding homestead and exempt property, exceeds the known liabilities. I have had small state affidavits filed by attorneys where the value of the assets were 50,000 and the value of the debts were 150. Sorry, can't do it. The assets have to exceed liabilities. One of the things that's required that many people will put that there is no application or receipt of Medicaid on or after March 1st of 2005. That is from the Texas Human Resources Code, Chapter 32. And we have 3 blocks for you. 1, decedent never applied. 2, the decedent did apply, and MERP is making the Medicaid Estate Recovery Program is listed as a liability. I have seen small state affidavits filed where box 2 is checked, but they kind of forget to put the MERP claim on it. That doesn't work. And then the third one is they did apply for it, but there is no Medicaid claim. And that's very common. If the applicant who's going to be filing this contacts the Medicaid Estate Recovery Program and receives a certification that the state is not going to go after the assets. Very common. But if you hit that box, that third box, you have to have the MERP letter as an attachment. If you can scroll down to the next page. Now, this page here is very critical. It's all of the assets. You have to give enough of a description so that the asset can be identified. And we request that you give X's and then the last 4 digits of the bank account number and the bank's name, or some identifying information on a life insurance policy, for example. If you're trying to transfer a car, we need the VIN number. And critically, the address and legal description of real property if you're trying to pass title to the homestead. And then you have the value of the assets as of the date of the affidavit. I have seen attorneys file these and they'll put unknown or a question mark for the value on a bank account because the bank won't give them information. If the bank won't give you the information as to how much is in the account, you can file under Chapter 153 an application for access to financial information, and the court, and you can file that under a small estate affidavit number, and the court will issue a court order ordering the bank to disclose the information. And then on the third column, very critical, was the asset community property? Was it separate property? And you have to give facts and explain why it's community or separate. And then very critical, under the insurance code and the Texas property code, is the asset exempt or not? Now, 205 requires that all assets of the estate be listed. And that means if you've got a lake lot out in Bonham, you got to list the lake lot. Well, if the lake lot is not the homestead, can't use a small state affidavit. It's one of the reasons why the 205 requires all assets to be listed, because you want the entire estate and what you're trying to collect. And under 205-008, the only real estate that you can transfer title to is the homestead. Cannot transfer title to any other real property. If you could scroll down, please. At the very bottom, underneath this box, there's a little note. A small state affidavit can only be used to transfer title to homestead property, to a spouse, or to minor children. 205.006 says that you can transfer title of a homestead under this affidavit, but it's limited in under 205.008. It directs you to look at Texas Estates Code section 353.051, and under 051, the number 1, it indicates that you can transfer title of a homestead property to a spouse or a minor child. And it's further, it comports with the Texas Constitution, Article 16, Section 52. If you need if you have too many assets, you can add another page. Now, the largest estate that I have seen passed, I'll answer that in just a second. The largest estate I have seen passed with a small estate affidavit was 1.2 million. You had a residence that was valued at 600,000. You had a retirement account, which is exempt, that was valued at 550,000, and you had $50,000 in a check account. There was no will, and they were trying to clear the checking account. So if you look properly, when there is no will, you can get some large estates passed if the property falls within the constraints of Chapter 205. And then I was asked if there was an adult child. Many, many years ago, an adult child living in the residence, theoretically unmarried, could get title to the house, but that was changed, and now Article 16, Section 52 of the Texas Constitution limits the passing of a homestead to a surviving spouse or to a minor child. And of the 3,000 small estate affidavits that I have seen over the past 5 years, twice we've had a transfer of a house to a minor child. It's very, very rare. If you could scroll to the next section, please. Okay, liabilities. There are two types of liabilities. There's the liabilities that are for a mortgage, for example. A secured liability has to be listed, but it's not counted against the assets. What you're looking for, what the estate is presenting here are credit card debts, medical debts, any debts that are generally considered unsecured. And theoretically, those debts would be paid by the bank if you're collecting a checking account before the rest of the money is given to the applicant. You need to give the detail on the liabilities and how much. Now, it's courtesy to give a total of the assets, and it's courtesy to give a total of the liabilities. I'm a CPA. I can do math. We check. We have no choice but to check. If you could scroll down, please. Now, this next section, underneath the liabilities, we as judges get very upset if we see a small estate affidavit used to collect a bank account that has, let's say, for example, $4,500 in it, and the attorney fees are $2,500. It's a little bit outrageous. We want to know how much we're paid and who paid those fees and essentially who they're paid to. We're trying to help the people out. You're not trying to make it economically unfeasible to do these. Now, the next section, here we get into, I'm asked the question, can title to homestead be transferred to a surviving spouse if there are adult children? And yes, that happens very frequently. Mom and dad have 3 children. Adult son is still living at the house. Dad dies, and the house is community property. The title transfers to mom if the house is community property. And we do have an interesting situation that is allowed if the house was dad's separate property. He inherited from his mother. His wife is living with him, and he had 3 children, and one of the sons is living there. And we know under the Texas Estates Code that mom's going to get a life estate even if it's dad's separate property. You can still use a small estate affidavit because as we get down to the right to receive section of the small estate affidavit, we're going to list out all classes of property and who is entitled to what share. But the first thing we want to find out is, on the date of the death, was the decedent married, or was he, or was the decedent single? And if they were married, the court's requesting the date they were married, and that's going to become important in a couple of minutes. If you'll scroll to the next section, please. Now, this section right here, it's a very large section. It's under section 201, chapter 201, and under 201.052, if the decedent is a male. Well, we have to plead the presumptions of paternity, and they're listed here. And as you'll scroll down a little bit to see the bottom part of this page, you're going to list the child's name, the date of birth, name of the child's other parent, and then beneath this, there are a few lines that are there that allow you to explain if you have 3 children, for example, first child, second child, third child, their dates of birth, the name of the other parent. If all 3 of them are born during the marriage, you would indicate all 3 children were born during the marriage and are children of the marriage. You're explaining the presumptions of paternity and how they are met. And that's what the section here is for. It also comes into play when there is separate property and community property. If the children are not the children of the marriage, if they are children from a prior marriage, well, then they're going to receive the decedent's share of the decedent's community property. If you'll scroll down to the next section. Here's where we start running into problems. If you have predeceased children, for example, decedent is married, had 3 children, but one of them died as a teenager, where you're going to list the name of the deceased child and the date the child died. And did the child have any children? We get into a situation where you have grandchildren, but their parents had died, but their grandparent is the one who has now died, and you start running into problems on these as to who can sign and when the person died. These can get fairly complex. Scroll down to the next section. We're going to list the parents, because if the decedent had no children, was he survived by his mother and his father? Maybe if he's only survived by one parent, the other parent's going to get half. But if both of the parents deceased before the decedent did and he had no children, was not married, then you're going to go to the next section and start listing, if you could scroll down, please, brothers and sisters. This happens frequently. We have a decedent who was not married, had no children, died at the age of 75, both parents predeceased, but he's got a brother and a couple of sisters. Well, we're going to state who they are and whether they are full or half siblings. That's because a full sibling will receive twice the share of the estate that a half sibling will. And we want to know their birth dates. And then beneath that, if any of the brothers or sisters, if that's the situation that we're dealing with, did any of them predecease the decedent, and did they have children? And if they were a predeceased brother or sister, whether they were a full or half sibling, because that's going to determine fractionally what the share of the interest is. If you'll scroll to the next section. Now, you're going to fill out a separate page if the decedent was survived by none of the following. If he did not have a spouse, did not have a child, did not have a grandchild, didn't have a parent or a brother or a sister or a half brother or a half sister or a niece or a nephew, you're going to get into what a very detailed description for a determination of heirship, essentially. And that's what the small state affidavit does. If you'll remember, under chapter 202, under determination of heirship, you list all of the relatives, all of the people who would take in the estate, and you have 2 disinterested witnesses. That's why you have 2 disinterested witnesses signing on this affidavit form. If you'll scroll to the next section, please. I've got a question that says, okay, am I still, I don't know if I'm still being heard, if I'm still on or not.
You're still on, Judge.
Okay, I've got something else on my screen, but that's okay. I was asked, do attorneys write in or fill in these blanks? One of the reasons why I asked, why I've pointed out that you can get this form in a Word version. If you get it in Word version, you can go in and edit and type everything in that you need to. You can take sections out that are not applicable, and to get the form on an emailed version. If you have Adobe Pro, you can pull the form off of the Dallas County Probate Court's website. The form is there in PDF, and Adobe Pro will allow you to go in and fill in the blanks. Although I have had an attorney print the form off and hand write it in. So yes, that is possible. But here you're going to list for each of the distributees, all of the heirs. You're going to list their name, address, their telephone number, their email address, and there are 3 columns. They're separate, their interest in separate personal property, their interest in separate real property, and their interest in any community property of the decedent. And even if you have a situation, and I've seen small state affidavits where you have a spouse married for 60 years, you have 3 children, all of the property is listed as community property. And I've had attorneys try to send this in with just the spouse, indicated all the property is community property and that she's the only one who's going to get all of it. And it's rejected. It's rejected because you have to list all of the children and you have to list their interest in any separate personal property and any separate real property. Wife would receive a life estate and the children would get their fractional interest of the separate real property subject to the surviving spouse's life estate. And then in the situation that I was just describing to you, the community property, the children, if they were all children of the marriage, they would receive none. And we require this for a couple of reasons. Number one, it's a notice issue to all of the children. And 2, we have been informed that there are some constitutional county courts in other parts of the state that are using small estate affidavits as a de facto determination of heirship. And so for those 2 reasons, we require all of the children, even though they may not be getting any of the property, and we require all the children to sign and become part of the affidavit. If you'll scroll down, please. Now, this at the note at the very bottom says,
Judge Monroe, are you still with us? It seems we're having technical difficulties and we just lost Judge Monroe. Give me a few minutes to see if he lost connection.
okay, can everybody hear me now?
Yes, you're back on, Judge.
Okay, I apologize for that. I have a Zoom hearings that start immediately after this, and the system was treating me as though I was back in with a Zoom meeting, and I had a question across the board, across the bottom of the board, and I can't remember the question now. And I cannot see the form. I don't know if you need to reset the form up or not. Okay. The note at the bottom of these columns are, in all estates, doesn't make a difference what it is, in all estates, the first two share columns are mandatory, even if there is no known separate property. The third share column is used when there is a surviving spouse. For separate real property, use LE for life estate and STLE for subject to a life estate. And we require everyone, every heir, to join in, every heir who would be entitled to property under Chapter 201 to join the affidavit. It is a notice issue. If you could scroll down, please. One of the things I want to point out here, this is a part of the affidavit, and the distributees, this is a restatement or a part of 205.007. Every person that signs the affidavit, all of the heirs, and that's why we require all of the heirs, even if they're not going to be receiving property, it's a notice issue, and if there is something wrong, everyone who signs the affidavit is liable. So if we have people who have not been truthful on an affidavit and they go in and they collect a bank account and then we find out there are other heirs, even the disinterested witnesses can be sued to collect the money. And so we require all of these, and you would be stunned at how many of these have a jurat that is invalid. The jurats, if you'll scroll down a little bit, please. This is a jurat, and I've had the distributee's signature and nothing else, and the notary notarizes it. If the jurat is bad, the affidavit's bad, and they have to file an amended with their proper jurat. These are checked. Every single piece of these are checked to make sure that it is valid, and you have to have a valid jurat for each person who is signing the affidavit. And we've provided on this form for 4 distributees and 2 disinterested witnesses. When there are, for example, 6 or 8 distributees, you have to add pages, have to add jurats to get all of their signatures, and these are verified against the list that are listed on all of those who are entitled to receive property and what their share is. We verify each and every one of those signatures. We verify that each and every one of those individuals that are listed have their signatures. Now, I've been going fairly constant now for the past 35 minutes, and I wanted to leave time for people to send in questions. Now, the Word version, and this is the question that I've got, Charlotte Key is the staff attorney for Probate Court 2. Her email address is Charlotte, CHARLOTTE .key, K-E-Y, at Dallas County, DALLASCOUNTY.org, O-R-G. I asked her if she would email out the Word version if she receives a request, and she said yes. So you can send her an email saying, I would like a Word version, and she will attach it and send it to you by way of email, and then you would have it for those who don't have Adobe Pro. Now, it is an interesting point. If the statute of limitations on a debt, meaning that the debt is not collectible, has run, do you need to list that debt? No, you don't. You're listing debts that are valid on the date of the affidavit. And if a debt's not valid because it cannot be collected because the people sat on their rights and didn't do anything, then yes, you don't have to list those debts. Now, the 3 most common errors that I've seen on small state affidavits, and one of them is fatal, and I see it approximately 30% of the time, and that is when you're trying to pass title to property that's not a homestead. Now here's the situation. Let's say that mom's a widow. She is in the family homestead that she has had for 50 years. Mom passes away and she's got 3 adult children, Jack, James, and Janie. And so an attorney says, well, I can transfer that homestead to Jack, James, and Janie, and they file a small state affidavit. That's fatal. You cannot use a small state affidavit to pass title to that real estate because homestead interest is a possessory interest. And the minute mom died, there's no more homestead. You have to do a determination of heirship with an administration to pass title to that house. And I see that all the time, trying to pass the title to a piece of property that you may think has a homestead on it, but it doesn't. That's number one. The second biggest mistake I've seen, the $75,000 limit is a hard and fast, bright line, black letter law rule. And we do the math. And I have had attorneys who will submit a small state affidavit that says estimated value of a bank account is $70,000 and a couple other assets, and they say they're under 75. We're going to require you to prove up the non-probate assets. Yes, they are included, and because 205 requires that all assets be listed. Now, if the non-probate assets are exempt, and this is where a classification of the asset is very critical. Is it exempt or not? So yes, you have to list all assets, probate and non-probate. But getting back to the 3 most common mistakes, one is in execution, one is in trying to pass title to real estate that you cannot, and the third one is jurat execution. I see jurat execution problems on a continual basis, and what happens is that, and I've seen this, an attorney will fill out a small state affidavit for a family that's got 8 distributees, and their client says, well, I'll go get everybody's signature. And they take the affidavit and they run around to 3 or 4 different notaries, and somebody doesn't sign it properly. It gets rejected, and that can be very, very frustrating. Now, in terms of just general questions, I think I can click on this chat button to see questions. Can a person agree that their permanent residence is in Texas with their adult children if they are working out of state? Would the Texas probate courts recognize this? If they're doing it, if you're not trying to pass title to real property, yes. If everybody says dad lived at 2412 McClure, Irving, Texas, and he was working out of state, but his intent was to return back to 2412 McClure, sure. That's his residence. You don't have to prove it up, but typically, where is he registered to vote? Life insurance is included, and we've seen small state affidavits used frequently to collect life insurance policies. Let me see. So life insurance is included. Now, the next question that I have is, why do you need to list non-probate assets if they have passed already and you're not trying to collect them? 205, it's what the code requires, but it's the assets. For example, if the asset doesn't exist anymore because it's already been collected and dispersed out, you don't have to list it. So if you've already collected a life insurance policy that's paid out per its terms, it's not an asset of the estate. But if you're using the small state affidavit to collect a life insurance policy, then you have to list it. The next question is, would I suggest a small state affidavit prior to handling a foreclosure for an adult child living in deceased mom's home? Well, what purpose, if you're trying to do mom's estate and mom has the house and there is no spouse, you cannot use a small state affidavit prior to the foreclosure, because the small state affidavit would not be approvable in that context. The next question is, I mentioned if a will was made, one can't use a small state affidavit. What if the will wasn't probated within the time limits of the estates code? Well, number one, you can probate a will as a muniment of title after 4 years. Number two, you can, under section 301, the 4-year limitation has an exclusion. You can use use section 301 to ask for letters after 4 years under a couple of certain circumstances. The fact that there is a will means that you cannot use a small state affidavit. Pension plans that have a distributee. Pension plans are exempt property. They have to be listed. You list them, they pay out according to their terms, and they are exempt under Chapter 42 of the Texas Property Code, excuse me. And then the next question is, would the beneficiary not collect on the life insurance policy? And a beneficiary would, but there are times, and my own stepfather on his life insurance policy put out that it would be paid to his estate. And that was allowed by the insurance company, and then you had to do an action to get that policy. So yes, you can use the small state affidavit to collect insurance policies, and I've seen that happen many times. Do I have any more questions? We've got a few more minutes.
Judge, we do have a few questions from the Q&A box, and I can go ahead and read a couple of those to you.
Well, wait a second. Okay. How are jurats done when the distributees are in different countries or different states? I've seen this happen. I've had distributees that are in Europe, and I've seen the attorneys email them a copy of the small state affidavit, and that they go to the U.S. consulate and have their signature notarized at the U.S. consulate. I've seen them at the U.S. consulates down in Mexico. So you end up having a very lengthy small state affidavit, but you can tack a small state affidavit with a jurat that's properly executed outside the United States to the small state affidavit that you're trying to enter into the court. What is the best method to transfer separate real property that is the only asset to decedent's 4 kids? Well, that would be through a determination of heirship with no administration. The order on the determination of heirship indicates that there is no administration, and it contains the text that's required under a muniment of title. Now, the next question says, did you just say a small state affidavit can be used to get the proceeds from a life insurance policy as long as the policy is under $75,000? Yes. If you have a $10,000 burial policy, I've seen many small state affidavits to collect that type of an insurance policy if it's under 75. If you get out a $150,000 life insurance policy, can't use a small state affidavit. And it says, what if the decedent did not designate a beneficiary? That's where you would use a small state affidavit, because the decedent did not indicate a beneficiary. It would go into the decedent's estate. And then the next question, are non-probate assets like pay on death accounts listed as exempt from the $75,000 limit? If they've already been paid out and collected, they're not listed on it, but it depends upon what the asset is as to whether they are exempt or not. If it's a pay on death checking account, it's not exempt. But if it is a pay on death retirement account, it is exempt. You have to analyze each of the assets according to whether they're separate or community property. And then once you've determined whether they're separate or community, are they exempt or not, using Chapter 42 of the Texas Property Code, and also for items from the Texas Insurance Code. Would the beneficiary not collect, last clarification, 401k and pension can pass through a small estate as well? Yes, they can, because 401k and pension are exempt assets under the Texas Property Code. Do I have any other questions? Well, you're going to love me, because we're supposed to stay here for 50 minutes or 46, 47 minutes. I think that's good enough for me. I hope it's good enough for you. You will need to.
Yes, thank you, Judge. Please report your CLE credit to your State Bar of Texas profile. I can read out the CLE number, and that is 174088382. And again, it's also included in the chat function. You'll also receive an email with that number following today's presentation. If you would like a copy of the small estate affidavit, again, please email Charlotte Key, and her email is also listed in the chat. Again, thank you, Judge, for presenting, and everyone for joining us this afternoon.
All right, and the last thing I do want to say is Probate Court 2 is having a series of presentations as part of a probate summer school. We're working in connection with the Dallas Bar Association's probate bar section, and next Tuesday is going to be one of our first sessions, and it's going to be as beneficial as the small state affidavit session you saw today. So I'm going to recommend, if you've got the time, to go to Probate Summer School. And a shout out to Elaine Mosher, who I used to work with back when I worked for Legal Services. And with that, I'm going to leave the session. We are at 12:59, and that's 49 minutes out of 50. And to all the people who are telling me thank you, you are all very welcome.
Thank you. Everyone have a good rest of your day.